Thank you, Carrie. I appreciate that. And again, I've already received a wave of questions that I'll direct to you later on. Before we transition over to Greg and Neil, just as a friendly reminder to everyone to please mute your lines. We're getting a little bit of feedback looping in on the audio, and really appreciate it if you could mute your lines. And then we'll go ahead and transition off to Greg. As I understand it, you've worked for both commercial and residential construction companies in operational capacities. So you really have a unique perspective. Can you walk us through kind of the contract implications of what we're all facing with right now? Greg?
Sorry, I was on mute there. Thanks, Damon. I think Neil's going to take this first section about the shelter-in-place orders. Are you there, Neil? You might be on mute as well. We can actually just go to the contract section and.
Greg, I'm sorry, this is Tim. I've been manually muting people in order to keep the call clarity good. If Neil can shoot Damon an email as to what name he is listed under on the call in, I can manually unmute him.
Okay. Let's see.
Apologies, everybody. If you'll just hang on for a second. We're just doing this so we can cut down on the feedback during the call.
Yeah, and while they get sorted out with that, I'll just talk generally about what we're going to talk about. That should only take a couple seconds. First, we're going to talk about shelter-in-place orders. And Damon, you could advance to the next slide. I know there's been a lot of different orders. There's been local orders and there's been the state orders. And Neil's going to address that. Then I will talk about your typical contract provisions regarding unavoidable delay, because that is something that I'm sure is going to come up in these, in the next few days here, both from a GC perspective and from the subs perspective. Maybe what we should do is start with that, and then Neil, maybe you and Tim and Damon can figure this out on the back end. So let's do that. So Damon, can you advance another slide? One more. Okay, so what I'm using as a model here is the AIA contract. I don't necessarily recommend that for general contractors because they're very developer owner friendly, but they do have the essential terms that most contracts have. So the AIA boilerplate, you'll be able to find that, the elements of that in almost any contract. So it's a good reference point. The A201 contract, if you're a contractor who works in private works, I'm sure you're familiar with this, has a section for delay called contract time. That's section 8.3.1. And we have the text of that up here on the slide. And I've edited it out just to, not to overwhelm you here. So the operative provisions here say, if the contractor is delayed by, and it gives us a list of several different items, reasons for delay. What's pertinent to contractors and subs here is subsection 3, which is an unusual delay in deliveries. That can obviously happen here with coronavirus. Unavoidable casualties, which we hope does not happen, or other causes beyond the contractor's control. That other causes beyond the contractor's control is going to be what most people will rely on if they have delays that are directly caused by coronavirus. There's been an exemption for construction, so construction should continue as normal. And there's a chance that if as a contractor you have a delay that is attributable to coronavirus, the owner might say, well, you're exempted and you can work. In that situation, that's going to be a tricky situation, because you're going to need to prove that any delay you have is linked directly to the coronavirus. So people have been recommending setting up separate cost codes that are linked to the coronavirus and tracking your costs and time during this time to make sure that later on, if you need to prove that there's a delay that's directly attributable to this, you can isolate those costs. So getting back to the contract clause itself, the last section says other causes that the contractor asserts in which the architect determines justify delay. If you can document any of those things, then the contract time shall be extended overall. So your project end date should be pushed out. The key to getting extra time is documentation and notice. So you have the legal right in most contracts. This is, like I said, this is the AIA, but most likely your contract, if it's a custom negotiated contract or it's a consensus stock contract or a public works contract, has similar provisions. So Damon, if you could advance to the next slide. Let's talk a little bit about what you actually need to do to preserve your rights in this regard. Quick summary. So if the coronavirus causes delays in delivery or other delays that are beyond your control, you should be entitled to a scheduled extension. Next, we'll talk about how you get that extension. So next slide. Okay, so and this is also typical of most contracts, there's an interaction between the section defining delay and how you make a claim and how you give notice. So in the AIA 201, Article 15 defines how claims are made, and this is good to know generally. This is not just for time. So next slide. Okay, so this is the section that talks about how to make a claim. So we've established that you most likely will have a right to a delay claim, but you have to do the right things in order to assert that right. So to do that, if you need to make a claim, you have to give notice as provided in section 15.1. This is all within section 15 of the A201. That notice should include an estimate of the cost of the delay and the probable effect of delay on the progress of the work. Oftentimes, there'll be situations where a delay isn't discrete. There might be one cause and then there'll be a continuing claim. Under this contract, you only need to assert one claim, but you need to check your specific contract to make sure that that's also the case in whatever project you have. Next slide. So just to review, you in the AIA, if you check section 8, A201, you'll see you have the right to a delay if it's an unavoidable cause, but you need to make a claim for that cause in order to preserve that right. So if you see it, you'll in section 15, you'll see that claims by either party must be initiated within 21 days after the occurrence of the event giving rise to the claim. This is really important, and these timeframes are shorter in public contracts typically. If you have a delay, you need to write it down and you need to give notice as soon as you can, immediately. A lot of the contractors I work with, I don't think they appreciate the importance of this. You can waive your right to assert a claim for delay if you don't assert it in a timely fashion. And the rationale for that is that the owner and the lender need to know if there's going to be a delay because they've got financial obligations on the other end that they need to account for. So do not have a delay and have your PM send an email and kind of say, hey, there's a delay, we'll get around to telling you later, a couple months pass, and then you're trying to go back and say, here's your notice of a delay. By then it's too late. You've waived your claim and you're probably not going to get a schedule extension. And if you have liquidated damages in the contract, you're going to be hurting. So the last thing here is how do you, you can advance the slide, Damon. How do you give notice of your claim? One more slide. This is just a summary of what we just talked about. This last point about notice is very important because there are certain notices that like delay claims or like change orders that have to be served in specific manners. You can't just email someone unless the contract allows for that. So when we negotiate contracts, we often try to get the owner to accept notice via email, but often they won't. They will only take it, as you can see here on the slide, via certified or registered mail or via courier, and you have to give it to the designated representative, the owner's designated representative. So stepping back, those are the main elements of. And let me check my So the main elements you have here is if you have a cause that is beyond your control, you need to give notice of that cause very quickly, and you need to do it in the right way. The specifics of that in the A201 you can find are outlined right here. You can just go find a sample preview of the A201 online. But in your particular contract, it's almost certain that they're going to have the exact same elements. They might be worded differently. And you would just need to just look for notice, how you give notice, contract time and delay, and you'll find similar interacting clauses. So that's it. Let me check back on the back end here and see where we're at for Neil. Damon, are you having any luck with bringing Neil online, or?
I think we're still working on that, but in the meantime, we can possibly get some questions fielded if that works for either one of you.
Yeah, I'm looking at the chat bar here, and actually there are a couple questions that have come up. Someone's asked about what about a force majeure clause. That is a force majeure. Force majeure refers to an act of God, or the coronavirus would be a force majeure. But you have to a force majeure clause is that just means an unaccountable. an unforeseen or uncontrollable cause of something, cause of delay. Whether or not it says force majeure, that's what it means. So in this case, it's all about linking your delay to the cause itself. So, if there's a coronavirus outbreak, but it's in Southern California, no one up here has it, you can't assert a claim for coronavirus on those grounds. Or, another, I think, gray area that's going to come up is that if you have some staff that gets sick, you're not going to be able to claim a delay based on a few staff getting sick. That is because, in general, a contractor or a subcontractor, they take on the risk of having sick staff when they sign a contract, right? So you assume that, it's your responsibility as a contractor or subcontractor to staff your project however you do that. Whether it's with a temporary labor pool or whatever it is, that's not the other side's problem, right? That's what they're paying you for. So it's not gonna, it would be a very tricky argument to make to say our delay is the cause of coronavirus if you only have a small percentage of your workforce sick. Now, if it takes out everybody, then we might have an argument to say, okay, this is a situation that's like force majeure. That's so far beyond the contractor's control. They couldn't find any other workers because all the other workers are sick. We might be able to make an argument here that you get a delay claim. But to do that, the most important thing is to document and send notice of those claims, because even if you have a valid claim, you're not going to be able to legally enforce it down the line if you don't have documentation and if you haven't given notice of it. Carrie, I saw quite a few questions come up on the chat bar. I'm not sure if you've seen those. Do you want to address any of those?
Oh, I unfortunately have completely lost my screen's frozen. I've completely lost my video connection, so I can't read the chat box. So if somebody could read those for me, that would be great.
Yeah, Greg, let me take charge of the questions if you don't mind. Carrie.
Yeah, go for it. Yeah.
So we've got a couple of questions here. The questions being asked here is HR 6201, the 2 weeks paid time off. Is that in addition to or an existing sick leave policy?
Oh, that would be in addition to. So if you provide, for example, you have California paid sick leave, or you have your own sick leave policy, this is in addition to that.
Okay. And then I've gotten actually quite a few questions on this very issue of if it's a violation of HIPAA to require the employee to tell you the reason for taking paid sick leave under the Family Virus Corona Act, or does it need to be coded a certain way? And if it's for self-quarantine or personal symptoms, how should employers interact with their employees?
So I have honestly I don't know that it would be a HIPAA violation, and that is not something that is addressed under the legislation as it currently exists. Perhaps that will be something that will be addressed through the regulations. I mean, just looking at normal, the pre-COVID-19 FMLA, you were allowed to at least get documentation establishing, for example, that you were taking time off for a serious health condition. So I would kind of envision perhaps the Department of Labor might come out with a form that's similar. So it's asking, it probably would not be a violation if you're asking, does it fall, well, actually, I'm sorry, sorry, I'm getting the two confused. So for paid sick leave, you have those very specific reasons that it can be given. So perhaps the Department of Labor will come out with guidance on what you can ask, but I don't think it would be a violation to ask a very basic, straightforward question: does it fall under one of these circumstances?
Okay, that's very helpful.
And let me just kind of address another question that's come up is, are you going to be allowed to ask for a doctor's note? And, again, the statute doesn't allow it. It doesn't prohibit it. A lot of the federal guidance that's been coming out is trying to remind people that it might be very difficult to get a doctor's note right now. So maybe ease up on some of those requirements and accept an email or perhaps whatever the employee can provide. But I think we need to hold tight to see if the Department of Labor issues regulations talking about what kind of documentation, if any, is going to be allowed.
Okay. And is there any differences between how sick time is accounted for, at least tracked between union versus non-union or merit shops?
Well, okay, I don't know about tracking, but the law does have provisions that basically says an employer can comply with the provisions of this law if it's making contributions under a multi-employer collective bargaining agreement towards a plan that provides for time off that's equivalent to the reasons that are required under these provisions.
Okay. All right, that's very helpful. Hey, actually, this is a question for Greg. It says, what is the proper way to document what some would call the unintended consequences of the orders and all of the third-party delays that impact us? An example might be when a quarter of the project staff gets sick and cannot show up, which means there is an obvious loss of production. The client would respond that staff being sick doesn't constitute delays. Do you have any thoughts on how that employer would handle that?
Yeah, that kind of goes back to what I was talking about before, which is, if you have sickness in your company, that's probably not going to be an unavoidable delay unless it's comprehensive. Regarding documentation, that's contract specific. So, like we went through with the AIA, you need to send a notice within a certain time frame, in a certain method. Now, there's no, as far as I'm aware, there's no specific format for notice. You can just as long as people get the notice, in the right time frame via the right method. You know, it can be a Word doc that says notice of XYZ, signed by someone, you know, responsible for the job. So that's the most important thing. And again, it's about preserving evidence and preserving your rights for the future. So it's really, as the job is ongoing, mainly a paperwork exercise. And I just want to say something about that as well. If you're a subcontractor and you're having problems, you know, staffing the job because you have a smaller workforce and it's taking everybody out, what I would do is reach out to the general proactively and say, you know, these are the problems I'm having. What should we do about this? And maybe you can work out, you know, if you need to pull off the job, this is the date we stopped. This is where our contract was at, you know, and this is the date we might start back up. That would allow the general to search around for another sub to fill that gap. And that's important because, you know, you don't want the general to blow the schedule because that's going to flow down to the subcontractor. But if you can, you know, if you can document, if you can come to an agreement and document those things, then you avoid the situation down the line of trying to argue, you know, well, it was an unavoidable delay because of coronavirus, and the sub saying, in the general saying something like, you know, sickness isn't an unavoidable delay. You can avoid all of that proof and an argument by just getting an agreement up front and being reasonable about it.
Okay, that's very helpful. Thank you. Actually, I just received another question, and it's one that you know might provide a little clarity. Again, Carrie, you might want to jump in on this. It comes from an employer here. It seems that they should be able to proceed with exterior work with precaution, but what if they have an employee who chooses not to work? And the employer hasn't laid anyone off, but this person has informed the employer that they are they intend to fill for or file for unemployment. How does the employer handle that?
So I guess I don't really understand what the facts are. If the employee, let's say, for example, it's a situation where the employee is uncomfortable coming to work because they're afraid they're going to be exposed. So we've had a lot of our discussions in our office about this. These paid leave laws that we're talking about all refer to somebody being unable to work. So just to kind of set that aside, we kind of believe that if somebody is able to work, there's work available to them, but they're opting not to because of fears, that they are probably not entitled to leave under these paid leave laws. I will say that I have been telling my clients I would probably caution against firing someone. You might technically be allowed to fire somebody if their safety concerns are unfounded. You know, perhaps under OSHA that would be allowed. But I'm sort of talking to my clients about being a little bit more flexible here. And if somebody's refusing to come to work, fine. It's probably going to be unpaid leave, and whether or not they would then be eligible for unemployment benefits is up to EDD to decide. And I do think I don't know what EDD is going to do with that. They have had some indications on their website that I don't know, perhaps they would, but that's really an issue for EDD to determine eligibility, not the employer. And I guess I should, just as the lawyer here, you know, we usually make a disclosure at the beginning of these types of seminars that this is for educational purposes only, and nothing that we say constitutes legal advice. So, you know, again, a lot of this is developing and is new, and there's, you know, not really a clear way on how to proceed, but just exercising caution in the area of firing somebody who's scared to come to work is something you just really want to think about.
Got it. Carrie, actually, one follow-up here is, and I believe you had indicated this number earlier on, but just for clarification, again, how many employees qualify for a mass layoff? What's that exact number?
So under the state law, it's 50 or more in a 30-day period.
Got it. Got it. Very helpful. So what about certain specialty occupations, let's say within construction, let's say like a residential or commercial swimming pool, Greg, would that construction and remodeling company, would they be allowed to compete in progress projects at a minimum? And are they allowed to begin new projects for both residential and commercial swimming pools?
That's a good question. I don't know. I have a feeling like that would be stretching it, swimming pools, because that's not, at first glance, right, that does not seem like an essential construction service. I think the intent of the orders is to do construction for, affordable housing, highways, things that we would need, that are ongoing major projects and also would need an emergency. So I have a feeling that residential swimming pools wouldn't be included, but that's not, as far as I know, that's not enumerated in any of the orders. So that would be a gray area that would have to get litigated. I'll say a couple things about that. I think Neil was going to touch on this, but in case he can't get on the phone, the process is for violating the order. It typically would be a warning from the sheriff, tell you to stop work. So let's say you do go out and continue to build swimming pools. The sheriff is probably going to come by and tell you to stop. And if they do, then that's when you are definitely going to want to stop. If you don't, they'll come back and issue you a citation or misdemeanor. And that's, you can get a fine. I think it's $5,000, but I don't quote me on that. I could be wrong. And there could be jail time with that. So it's kind of a one warning, and then you're going to get hit with something serious process. So I'd be careful with that. Just use common sense. There is a gray area in general with construction, but if you're building a bar or swimming pool or something like that, it's not going to look like. I have a hard time thinking that would fit into the exempt categories. One other thing to touch on is safety on the job site. I haven't heard anything from Cal OSHA or anything like that, but I would imagine that for construction that is ongoing, they might, to the extent that they're still working, step up enforcement of COVID-19 safety measures on the job site. So I would recommend holding daily tailgate meetings, and in those meetings going over the hand washing and all the prevention measures to prevent the spread of the disease. So if OSHA comes to the site, or even if there's a claim, I don't know how this could be, but there's inventive lawyers out there. There's a claim that because of going to the site, I got coronavirus, and then something horrible happened. You want to be able to show that we were holding these tailgate meetings. Here's our tailgate, our tailgate flyer that says that we went over hand washing, we went over working 6 feet away from other people. All of the typical measures that you've been hearing about ad nauseum, hopefully, online and over the radio and stuff like that. Along those lines, make sure you have hand washing stations out there, so that if you get visited or by an enforcement officer or something like that, you can show that we have all these measures in place to keep people safe from the virus, and we're doing daily information. We're doing daily presentations about this to the workers, so everyone's up to speed.
Greg, actually,
hey guys, it's Neil. Can anybody hear me?
Oh, great. Are you there?
Yeah.
Hello?
Yeah, we've got Neil. Hey, before we transition over to Neil, Greg, you hit a great point that I think is worth repeating and driving a little deeper into, is to remind employers when they're doing their tailgate talks or their foremen are conducting their tailgate talks and speaking with the employees, to respect that physical distance barrier, and throughout the workday to do their best to respect those physical distances, as well as maintaining those higher, stricter washing standards. The last thing our industry needs is someone taking a photograph of a small cluster of construction workers huddled together, in close quarters or a foot or two apart from each other, and having that go out to a local media outlets to all of a sudden have some adverse implications to our industry. So I think it's worth a friendly reminder to employers to kind of push that message down the line. So Neil, it sounds like you've been able to break through our NSA grade firewall calling number. So I'm glad you're joined us. I think we are queuing up your slide. Can you give us a brief 15, 20-second introductory?
Yeah, I can, Tim, and I was thinking, I missed the entire section or talk given by Greg, so I don't know if I'm going to be overlapping anything that he said. So I thought maybe since we're sort of at the tail end of the call, that I could just jump on with answering questions. Right when I got on the call, the only thing I heard was swimming pool, and then Greg started talking about the tailgates, which I think are two important things that have been brought to our attention lately. A lot of clients have been raising these issues. Is with regards to the tailgate, I agree. I think we should, we're recommending to our clients to have, the tailgate meetings every day before each shift. And there's an outline that we're sort of handing out, and we can have it posted on the CRXB website. But it sort of outlines the things that you should be talking to your employees about. Again, maintain that six foot distance thing. But some of the things that we're recommending that you talk about have to do with, go over the symptoms, the fever, the cough, the shortness of breath, and the, the COVID-19 severe respiratory illnesses that can ensue. We also are recommending that you talk about how it spreads primarily. We're talking about the close personal contact. That's why the 6 feet is important. But touching and shaking hands, things like that. I know these are simple reminders, but it's important to kind of reinforce this. The touching and the shaking hands is important because people tend to obviously touch their mouth, nose, and eyes. Emphasize washing of the hands. Obviously the spread is through coughing and sneezing. Just remind the workers to cough into their elbows. If you're another topic is if you feel ill or obviously if you notify your employer immediately, just remind employees to pick up the phone before they even come into work. Stay at home except to get medical care. Clean all surfaces that are generally touched throughout the day. And then a critical one that you really want to emphasize during these site meetings is how people can protect themselves. You talked about the washing of the hands, disinfect the surfaces, often throughout the day. And it's critically important. Again, don't touch the eyes, mouth, or nose with your unwashed hands. Cover your sneezes. You want to avoid contact with people who are sick. Stay away from work or schools or other sick people if you have those kind of symptoms. So again, there's a checklist that we've been giving to clients. We can post it on the website if it'll help people just to have that at the
tailgate meeting in the morning.
Yeah.
Thank you very much. We'll definitely put that up on SRBX's website. Just kind of following up before we, since we're at the bottom of the hour here, and we want to try to get to the last few questions that I've got queued up here. I want to make sure everybody gets the answers they need. This is for the group, whoever is able to answer this. What if an employee is part of the higher risk age group, 65 or older, but they want to continue to work? Should there be some special considerations or taken for them? How does an employer address those kind of situations?
So this is Carrie. That's been a really difficult question to address. And there are, I was looking at these yesterday, the CDC issued some guidelines, and I wish I had them in front of me, but if you Google, just CDC coronavirus guidelines, they issued they have some very specific pointers for what to do if you have older people in the workplace. I mean, it's a lot of the common sense stuff, but you want to really try to limit their access, to the public. And again, I apologize. They had 4 or 5 bullet points that they suggested of steps that you implement with older workers. It's hard. I mean, you really want to encourage older workers to stay home. I mean, they're in the highest risk, and maybe some of them have not been wanting to because they haven't had access to paid leave. Maybe it'll change a little bit when the federal law goes into effect. But again, I suggest that you look at those CDC guidelines because they did address that specifically.
Excellent. That's really good information. I can see how that can be. I presume more and more information is going to be rolling out, and for us to kind of cull through and glean and be able to push out to our members to help kind of clarify.
Just to add. Tim, it's Neil. Just to add one point, I know people focus on the older generation, but per CDC guidelines, especially in our industry, you want to also remind the employees that it's not just the older folks; it's people who have compromised immune systems or individuals who have chronic medical conditions, heart disease, diabetes, lung disease. Those are out there too.
Good point, Neil. Thank you. Yeah. I think it's more of a catch-all advisory to any and all. Final pay question. If an employee has been furloughed, can the expected defined return date be extended?
Well, okay, I don't know what that question relates to. I really want to caution people about the uncertainty involved with if you're calling it a temporary furlough and you're not paying final wages upon the notice of the furlough, you're not cashing out accrued but unused vacation or PTO, there's a real risk there. Otherwise, really calling something a furlough, I don't know how much of a significance it has, because even people who are so-called temporarily furloughed are eligible for unemployment benefits. So again, without kind of knowing the context of the question, I just would certainly you can extend it. There's nothing to prevent that, but I'm concerned about the idea that if you've treated it as a temporary furlough and you haven't paid out final wages or cashed out accrued time off, if you extend it, you're putting yourself in an even more precarious circumstance.
Got it. Understood. Thanks for the clarification there. We've got our final question here that I'll throw out. Possibly Neil and Greg might be something that you, or at least Greg, you've touched on earlier. Will force majeure be considered for COVID-19 when enforcing contract language regarding liquid damages and time completion delays, specifically when a contract bond is in place for the project?
Can you repeat that again, Damon?
Sure. So with specifically with a contract bond is in place for the project, will a force majeure be considered for COVID-19 when enforcing contract language regarding liquid damages and time completion delays?
Damien, it's Neil. I can briefly comment on that. We've gotten a lot of calls on force majeure, and I know it's a word people like to throw around, but quite honestly, it's not very common in our contracts. We just don't see it very much anymore. And so I would say I'd make 2 comments. One is, you want to look to there's three provisions that usually exist in all these construction contracts. You want to look at your time extension, your change order, and your suspension of work contracts in terms of delay. If you're talking about the liquidated damages, how that impacts if there's a specific force majeure contract in the bond, you just want to read. I mean, it's going to be controlled by the language in in the bond or in the contract, and so you just have to read that specific language.
Damon, you still there? Yeah.
Yeah, sorry, this is Tim. Just back, we are coming in at the close of our call. I'd like to thank all of our participants who joined us on the call, and just want to be sure to say the tech challenges that we had along the call, we apologize for those. I think over the next several weeks, I would be surprised if every person who is working remotely doesn't end up writing code on how to create a better system for doing teleconferences. I'd like to thank Carrie, Neil, and Greg for participating on the call today and lending their expertise. Thank you very much for your help. As far as links that were in the presentation, when we post this to the SRBX webpage, the recording of this call, we'll also include the links to the web pages and resources that they referenced. As a reminder, just want to remind our members what was said by Greg and Neil. It's to have those daily tailgate talks with your teams. Make sure that you are reinforcing the CDC guidelines and the hand sanitizing and hand washing and the 6 feet social distancing so construction can continue on. And one note, this is something that we've heard from some of our GC members out on job sites. Your daily safety walk should include a review of your porta potties and your hand washing and hand sanitizing stations. We did get reports from some companies over the weekend that their sites were raided and toilet paper and hand sanitizer were stolen off the sites. Just to keep you updated, SRBX is working with our local and state partners regarding local county orders that have come out regarding the COVID-19 quarantine. We are working with those local agencies to make sure that those resources that construction depends upon, such as permitting counters and inspections by building inspectors, are taking place because it is essential work that helps us to continue with our work. Some of the questions that have also come up regarding what constitute as essential construction with the governor's order. It's our view, because the governor did not put bumpers on his order, he didn't put any codicils on what kind of construction was deemed essential, is that all construction can continue. We just remind you to please build safely, observing the CDC guidelines and the social distancing, so that privilege is not removed away from the construction industry. And then the last thing, SRBX offices are closed during the quarantine, but I wanted to let everybody know that all staff is working from home. Our phones have been forwarded and we are here to serve our members. Our plan room is still operational with plans going in every day. We are still working on the advocacy issues to help keep our industry building, and we are working on workforce development even as we speak here, trying to help our instructors in high schools with projects that can keep kids occupied while they are home from school during this time. SRBX is standing by our members. We hope you stand by us. And as we have more information, I'll just remind you to visit the SRBX website, www.srbx.org, and check out the COVID-19 page for daily links and updates. Thank you very much. And as I said, a copy of this seminar, a recording of it, will be made available on that website. Thanks very much, and continue to build safe, everyone. Be well.